I want to thank Mr. Frazier for obviously providing this wonderful space and the food. Is this everybody's first time, second time? Who's been here?
First time.
Very cool. All right, we'll come back for dinner. Bring your significant other. Spend a lot of money. Take care of George, right? And the other thing too, I was going to say that these two wonderful gentlemen and George were down in Globe feeding 4,000 people. That's yeah, all last week.
It was George. I just drove back and forth.
So, anyways, yeah, just amazing people, and glad to be in the presence of community, and that's why I wanted to throw all this together. I've known Pete and I've known Craig for a long time. We work a lot together on all of this liquor liability and other stuff, and it's important to give value to those out there that are willing to receive it. So thank you. I want to thank all of you for just showing up on a Monday, because I understand we're all busy as heck, but we're going to try and give you some value to get out of here. We're going to make this, we have it structured, but we also want to make it open for questions and make sure that you all, since you have access to me personally, yay, whatever, but holy cow, Pete and Craig, and when the Phoenix Open comes, good luck. So now's your time to get some questions answered and take care of stuff, right? And obviously his staff is amazing as well. So we'll kind of dive into this here to get started. I do have a couple of faces in the crowd. We have an insurance guy in here. We have a couple of insurance people, just so that you know. And we have a couple of attorneys as well. So it's very, very exciting to have you guys all here. I will start with the aspect of insurance because it's probably the most boring, and then we'll get into the law side of things, and then we'll get into the liquor and let's just say the Department of Liquor and what's going on and some of the new rules and some of the things. So Craig will be very excited to talk about that. But first and foremost, to get into an insurance perspective and with what's going on with liquor liability, if you have not heard, we did actually, thank you to Mr. Pete Schelstraete here and amongst others, we did get the statute of limitations on dram shop condensed down to a year, okay? And it was 2 years. So now the plaintiff attorneys have only a year to file a claim as opposed to 2, right? That's big. That's big news. We will not really see a difference in the insurance aspect of things, and I'm sure insurance guys and ladies can shake their heads. We won't really see a difference until there's some sort of precedent set that shows that this is actually helping on the basis of claims. And Pete will get more into the aspects of common law and some of the things that have been relinquished, for lack of better terms. So we're still in an area in Arizona where liquor liability is still the most severe of claims that are out there. And albeit the law has changed a little bit, I am still seeing an influx of drunk driving claims. And if you've experienced one or two or none, I'm just going to tell you right now, they are some of the saddest and the nastiest claims that you can ever deal with. And when I say saddest, it's a tough position to be in, both as somebody that owns an establishment and is running a business, and you're in the business to serve alcohol, to bring community, to do things that people are coming in on their own to have fun and do things. But unfortunately, what will end up happening more times than not is that you will get sued for doing that. If there's an accident that is somehow tailed to your establishment during the course of that night. And I mean, just as of recent, I've seen a 21-year-old girl just get killed by a wrong-way driver over servants. I've had a married couple that got in an argument at a bar and then ended up blazing a red light and killing the person that was in a Uber and the Uber driver, okay? And they survived, and more times than not, the drunk driver usually always survives. And the drunk driver usually does not have a pot to piss in, okay? They usually have state minimum or hardly any insurance. And so at the end of the day, it comes down to, one of these things for the carrier to be like, okay, where are we at with this? We have a dead mom that's left behind 2 kids, and we have a place that served, liquor but what else do we have? And that kind of goes into play with what are we doing as establishments and as business owners to do the best that we can to preserve evidence, to get camera footage and to save that camera footage, to do the liquor training, and to have all of our policies and procedures and all of that stuff together, and to, you know, excuse my French, but not to be an asshole online with some of the stuff that we do. When that kind of goes into it and you're looking at underwriting guidelines with what carriers are looking at now, because of all these things, we have gone from a marketplace of new carriers coming into market to new carriers not really wanting to come into market. And if they do, they come with a bunch of stipulations. You know, we're going to give you a sub-limit on liquor. So now I've got people buying $250,000 worth of liquor and not $1 million, because the $1 million is a lot more money, and the insurance company's not putting that on the hook for the bare, you know, cheap of what it was. And there's not as many carriers out there to provide that or to do that sort of thing. So it's become like this supply and demand sort of thing, and it's really disheartening. You know, at the end of the day, has a broker, somebody that specializes in this. I know this sounds weird, and for those of you that know me personally, you'll believe this, but when I have to go to a client that's had one claim that I honestly know and feel is not their fault, right? It's a one drink or a two, and then I gotta come back to them and be like, your premium's going up 70%. It makes me feel like a jerk. I hate it. It makes me sick to my stomach, right? And that's kind of the marketplace that we're in right now. So it's not all gloom and doom, really. I mean, at the end of the day, we want to do all the things as far as, you know, look at what, you know, we're opening up new places. What are those risk factors? What's going to put us in, you know, this high profile tier as opposed to this tier where we can just get coverage and be like, okay, I can deal with that. That makes sense for my numbers, for my bottom line. And when we look at it, we look at operating hours. 2 a.m., again, can be a problem. Most of my direct preferred carriers are not writing anything 2 a.m. They don't want to be the last stop. That's just the reality of it, right, Justin? You're shaking your head. Entertainment type, you know, entertainment is always going to lend to somebody getting mad and somebody punching somebody. So, you know, you're getting into live music, you're getting into DJs, you're getting into, I've had cases, you know, where you have like video games, or you have like the punching game where somebody was like, actually, I think Gary, you and I talked about this, somebody was like doing that, how hard you can punch that thing, and end up like punching somebody else, and then there was a claim. I mean, I've seen a lot. I haven't seen it all, because none of us have seen it all, but I've seen a lot. So security measures, you know, the presence of bouncers, right? These big, you know, men or maybe women walking around with security on the back of their shirt, right? Just the presence of that alone can create some sort of an environment. And again, if that's what you're doing, and if you're going to be the stereotypical nightclub and do all of those things, then make a lot of money, because it's going to cost a lot to get you insured, unfortunately. And then the food to liquor ratio, that's always one too. That's one of the biggest questions I get asked by every carrier. Now most carriers are only wanting 35% liquor to food. Now there is let's just say, a fluctuation in that, and we all know that liquor prices have gone up, you know, significantly, or at least the price that you pay. So, you know, like a $5 beer is not really a $5 beer anymore, or I should say some of these specialty drinks that go on that are $14, $15, $16, we can fluctuate with, you know, 50%, or if it's a fine dining, you know, restaurant with higher priced wine, then some of the direct carriers will look at more of a 50-50 ratio. But once you get out of that ratio, it becomes tough, because the more liquor you serve, the more there could be something that goes wrong that has to do with liquor, which ends up being the biggest claim that there is. And then, you know, previous claims history, that's always going to make a difference. Whenever, you know, there's a thing called loss runs, and those things stick with your establishment, with your LLC for the life of the business. And when you're going out and you're looking at, or I'm going out to re-rate something and I'm looking at a new carrier, the new carrier wants to know what your report card looks like, and if you got a couple of F's on it, they're probably not going to take it, right? So then that's when you got to go to excess surplus and do this whole thing. And from a standpoint, so you guys understand with like what we do within, and this is why I've niched in this, because I don't have time to write apartment complexes. I don't have time to write I don't know, office condos or RV parks. I just don't have time, because to take one hospitality risk, it literally takes me and the staff, which we're grateful for. Don't get me wrong, I'm not complaining, this is what we do, but to do the best job that we can, we've got to go to 15 different marketplaces. I got to answer 15 to 30 different questions from all these underwriters to be like, hey, what about this? Hey, I saw this online. Hey, their website says this, but it's this, and that, right? And we're going back and forth, and we're documenting all this, and then we're coming down to the best 5, maybe 2 quotes if we even get it, and then what coverages are missing in those quotes, and we got to explain it to you, because most of the time none of you guys read your policies. I get it. I mean, you don't have time for that. You're running restaurants, right? Maybe some of you do, but a lot of times I'll get stuff back and there's a weapons exclusion. Oh, hey, DELO, somebody got shot in my parking lot. Am I covered for this? Well, no, you signed right here. These are the things that are going on. They're cutting coverages and they're just doing a lot of stuff that's not there anymore. So, yeah, that was kind of Debbie Downer, but it's the reality, right? So, again, it just to kind of to end this up on my perspective, it just comes down to risk mitigation. It comes down to learning and having valuable assets like a Pete, like a Craig. I'll throw myself in that mix to be able to ask those questions, and especially before you do stuff, like if you want to do pickleball at your place, right? And understanding the liability of that. Ask those questions too. If I'm not your broker, I think most of you guys I am, and I'm grateful, thank you. But ask those questions. Always feel free to reach out and to know what the complications, if any, could have on your coverage, and if it would be covered or not covered. And then you have to weigh the risk reward, right? Are we going to make this much money to stay open till 2 in order to alleviate the extra cost and do all that sort of stuff? So with that being said, I will now hand it over to Mr. Peter Schelstraete.
And thanks for inviting me. It's always great to be with both of these guys in any situation. Usually we're out drinking. So what I wanted to do was to kind of go over generally the big picture, the landscape, and at least give you a kind of a preview of what you could be facing, so you kind of have a framework to operate from. So I'm going to move that through that kind of quickly, but then we're going to get into the real meat stuff of what to do if something really bad happens. And hopefully you have an insurance policy, because that's probably the most important thing that you can do as far as advice goes. So there's 3 categories of sanctions that you can face. First, the most important piece of paper on your property is called your liquor license. This is the administrative law part, and obviously the Arizona Department of Liquor Licensing Control has a field of investigators that enforce the law. You also have, as far as law enforcement goes, you're also going to have the city, the county, the state, DPS, the liquor department. All of those can write you tickets on your liquor license under Title IV. But as far as the administrative sanctions go, is you're going to have potentially fines, minimum of $300 per violation, a maximum of $3,000 per violation, and then of course you could have suspension, and then the worst is revocation. So what's going to end up happening is, depending on the severity of that sanction, is whether or not you need to account for the attorney or not. Obviously, if you're looking at for a suspension or revocation, then it's probably behooves you to at least contact your attorney and say, hey, this thing happened, what do you think, and kind of get some guidelines on that. To give you sort of an idea of how the case progresses, so you have an alleged liquor violation. The liquor department is going to have somebody write up a report saying, I think there was a violation, and they're going to send it to a compliance section of the liquor department. Compliance officer is, right now it's Lyman Anderson and Dave Hines. And they will be contacting you. Now they can do 2 ways. If it's more or less a kind of a minor violation, they can mail you a mail-in consent, and they'll say, hey, if you sign here, you pay half the fine, and you're done. But that still goes on your record, and whatever they alleged as far as a violation is part of your license record, so you have to consider that. The other more serious cases is they're gonna call probably your agent up, which or if it's the manager, they may contact them saying, hey, we had 5 underage violations, we were thinking of you guys paying a $15,000 fine. Now at that stage, you're entitled through the public records law to get a copy of the investigative report that they prepared. And some people have told me that when they've asked for the report from the department, they tell them no, they can't get a copy of it. That's not true. Now there is a portion of on the website where you go to public records request, and you could give the date or whatever, and you're entitled to look at that before you enter into any consent agreement. Now one caveat is that if you're expecting a claim on your insurance policy, you're going to find that insurance policy in all 130 pages of the policy, it says in there, you can't take any steps that are going to complicate the insurance carrier representing you and protecting your interests. So they may offer you a fine, you admit to the penalty, and then the insurance carrier is going to go, hey, now you've admitted to fault, and now we can't defend you, and you'll get a reservation of rights letter from the insurance carrier telling you, hey, we're not insuring you for this. It doesn't happen. So it's very important that if you do have a serious, especially if you think that there may be some injuries down the road that may be coming in, and as you pointed out, the statute of limitations has gone from 2 years under the common law now to 1 year. But there is an exception. There are a couple exceptions to that. If the plaintiff is a person who's under 18 years old, it's told till they become 18. So if there's a child in the car, if there's a car accident, they may be 10 years old. That claims the statute of limitation doesn't run until they're 18. But in any event, you do want to, if there's a claim, while the insurance carrier is going to assign an attorney to represent you, and before you sign or admit to anything, you want to contact them. At that stage, you can't resolve the case, and sometimes, most of the time, the liquor department kind of waits for the civil action to be over with. I mean, that's kind of generally what I've been finding. But if you can't come to an agreement, then the liquor department then files a complaint against the business entity that holds the license in what's called the Office of Administrative Hearing. And that is a state agency that has a pack of judges, and those judges hear cases, and it's kind of like a mini trial. So if the liquor department has an assistant AG that is assigned to represent them, then you can represent yourself, or you probably should get an attorney to represent you, and they put on their witnesses. The state has the burden of proof, but it's a pretty low standard. All they have to do is prove. It's not like beyond a reasonable doubt. It's by preponderance of the evidence. In other words, it's more likely than not that violation occurred. And then, but they have that burden. So if it's 50-50, the judge can't decide, you win. But if it's 51%, you lose. Then you have the administrative law judge will make a decision. There's currently some pending issue because they changed the law to where if you, let's say you get a favorable decision from the administrative law judge, if you, with 10 days, you go, hey, accept that decision, it's supposed to be then, that's the final decision. The Attorney General's office is challenging that now, as they're saying that you can't do that in a regulatory setting, and so that's up in the air. But if the AG's office is correct, then you can file the 10 days. You say, hey, we accept the decision, but it could end up that they will go back to what the AG thinks should be argued, and that is that the director of the liquor department gets to look at the findings of facts and conclusions of law of the OA judge, and then he can accept or reject that. However it turns out, if it turns out negative for you, then you can appeal that to the liquor board, The liquor board is comprised of 6, 7 members. Some are in the industry, some are not. They're from various parts of the state. They're pretty even-handed, I think. We have a pretty good liquor board. Now, they make a decision. If they decide against you, then you can appeal that to the lower court of appeals. And now there's a new set of laws that are impacting those cases that are kind of in flux, in that the lower court of appeals now is not supposed to give any deference to the agency and the agency decisions, and you're entitled to potentially a trial de novo and to have, bring in new evidence. And so that's still all in flux at this point. And then, of course, if you don't like the lower court of appeals opinion, then you go to the court of appeals, and then you can go to the Arizona Supreme Court. So that's kind of that's sort of the big picture. And the time frame on that really kind of depends. I have some cases that, my client didn't even know a violation occurred, and then 5 months later they're getting a letter about something that happened, and it could be because local law enforcement put together a report, and then they sent it to the liquor department, and then they're following up. So you have and some cities are really good at doing their police reports, involves a liquor license establishment, and they send them to the liquor department right away. But if you're lucky and you live within a local law enforcement and they never send any of those reports to the liquor department, then God bless you, because then it just disappears. So let's get to but also when you have local law enforcement goes, is they are going to more likely to write criminal tickets. So the other type of sanction you're subject to, in addition to your liquor license, is that the police officer can write, let's say somebody is, an underage is served, okay? They're gonna write a ticket to the underage person, but they're also gonna write a ticket to the bartender that served them. And the way that process, just to go briefly about how what happens is, both the bartender and the server are gonna be, have an arraignment. And that's usually about a month after the event occurs, where they have to go to either a city court or justice court, and they're going to go down there. And that's all that arraignment is for them to plead. Now, to plead responsible or not responsible. I always tell them you should always plead not responsible and tell your employees to plead not responsible, because then they're going to set up for a pretrial conference. And at the pretrial conference, which will be about another month later, they're going to have the police report there for you, and they'll have an offer to resolve the issue. And sometimes you have to take a class or a small fine. One of the issues that comes up that I get a lot of questions like, well, what if my bartender pleads responsible to this thing? But we think that there is justification, we should be held responsible for this. Can that hurt me? And yes, it may hurt you, but as long as it's not you that's pleading, it's not what they call like res judicata, it's not for sure. And then your argument is, hey, you just did that because you didn't want to have to hire an attorney, and it was a $300 fine, or you had to take a class or whatever. So, and of course, with any criminal sanctions, they're mostly always fines. Sometimes I've had clients who are arrested that night, but it's only because local law enforcement doesn't like that owner. And they always seem to, I don't know why you're missing shoes the next day. They don't know where one of their shoes are. It's in the squad car, the phone's gone. But if you have a good relationship with law enforcement, you'll probably just get a ticket, that night. There are instances, of course, he mentioned, these fatal accidents and the person doesn't have any insurance. Those people are going to be charged, probably with a felony, and they're probably going to go to jail. And if they're convicted, there's cases I've had that are 20 years old, and some of these people are still in jail for these accidents. So you have the administrative power, you have the civil sanctions, which these are not really sanctions, but this is where the insurance policy kicks in. Although, one of the things that I'll say, and we have a couple of attorneys here, so I don't know if they've had this experience or not, but sometimes the insurance company carrier is supposed to protect you and provide defense, and sometimes they will cover the liquor law attorney representing you in the sanction part of the case or the criminal case, because a lot of the facts are kind of rising up in the same circumstances. So, and having a combined team is definitely better. The other thing too is the insurance carriers tend to be kind of like, to me, sort of like behind a little bit in getting counsel in. So, and there's a lot of, and we'll get to this later, but there's a lot of things that go on like right away, and you know, you don't have an attorney for 3 weeks or even a week, or maybe longer. Then you know, now it's, you know, there's a lot of things that are getting put in cement that are going to be really more difficult for your attorney when you do get one down the road to represent you. You know, now they've had all the interviews, you've had, you know, all the facts and everything, and they kind of, we'll talk about this more, but that could, you know, kind of hurt your case, so, in my opinion.
Let me interrupt you real quick, just to kind of play off of that. So, when somebody gets a letter that Goldberg and Osborne is, you know, wanting all of your stuff, correct me if I'm wrong, you do not give that to Goldberg and Osborne. That's when you contact me, your insurance broker, whatever, and then we need to turn that over to the carrier immediately and say, this is, you know, the possibility of what's going on, and then you preserve your own evidence for yourself, but you do not hand that stuff over to enemy territory.
Right, yeah, absolutely. One of the most important things is if you do have, so you know there's been a serious accident, you're gonna have to expect these litigation, notify your insurance carrier. Another clause in the 145-page insurance policy that you have requires you to timely, you know, let them know. And Dave's actually awesome because he's been around the block and he knows all this stuff. And so when you have someone that specializes in an area, they kind of know what issues you're going to have and kind of guide you on that as well. So the civil sanction part, though, the biggest lawsuits that you're going to face are going to be from wrong-way drivers, grab shop cases, which are grab shop cases, people you're serving, and whether or not you serve too much. Now, I'm going to give a shout out to ELBA, Arizona Licensed Beverage Association, as well as the Arizona Restaurant Association as well. Both, though, first ELBA had an attorney, Don Isaacson, in 1986-87, who drafted the statutes that limit your liability and exposure in grab shop, and that was really all ELBA. And now, of course, about a year after those statutes were passed through the legislature, the courts found that they were unconstitutional, and so they weren't available for about 25 years or so. However, recently, through the Torres case, which was a dram shop case, and I won't go into the details of it, but in any event, one of the issues is, you know, they claim both common law and statutory violations, and the Arizona Supreme Court confirmed and found, and now is the law of the land, that there's really only two circumstances in which you can be held liable for dram shop, and it's written in the statutes. One is to under 21, you can be held liable. The other is if you serve someone who's obviously intoxicated. And I have up there, which I'm sure you all can read from the back.
You can email it to you.
I'm just gonna, because this language is so important, it's not too long. They actually define what obviously intoxicated means in Title IV, and this is the standard. It says obviously intoxicated means inebriated to such an extent that a person's physical faculties are substantially impaired, and the impairment is shown by significantly uncoordinated physical action or significant physical dysfunction that would have been obvious to a reasonable person. All all right? So that has a lot of protections in there, and that really raises the bar that plaintiff's attorneys now have to clear that hurdle. But it's still a kind of a gray standard, and you know, and of course, I always get this question: is should we have cameras in our, you know, because that will record everything, you know? And the answer to that is simple. If something occurs on your premises that is, you know, shows that you didn't do anything wrong, you need to have the cameras on. If there's something that happens that's questionable that may raise your liability later, you should not have so, but let me, so there you have it. But there's a middle ground that I kind of think is probably the best, because I've had clients that have really, what happens is we have cameras, and there's a wrong way driver, the liquor department gets the video, and they have somebody watching, they know which person is, you know, from the beginning to the end, and they watch that person and they might be there for 4 hours. Now, in 4 hours, if you watch someone, you know, did their foot stick to, you know, get stuck on the bar stool and it looked like they think, you know, is that gonna, you know, happen? So that seems kind of risky, because if they really want to find, look at that, look at, he dropped his pen, you know, and it could be just something simple that now they're going to make that into, you know, that he was obviously intoxicated. So I think that the broader answer to that question, should we have video, should we have video? I think you should have video for people coming into and leaving your premises. Because I think, because the other problem is the serving underage, and now with the fake IDs and, you know, the other half of the liability you can pick up, the gold standard is to have the person coming in and presenting their ID card, right? Then having a record of what ID card they're presenting. Because when the police show up, as Craig can tell you, who's the king of showing up when he was at the liquor department, surprisingly, is that now that fake ID is gone. And they go, oh yeah, I gave him this ID, and it says, you know, it's vertical, you know, there's 17, you know, and the other ID card's in a garbage can, or it's not on them, and, you know, how then are you going to prove that the person gave, you know, because the IDs that they're making now, they're, you know, they're using the same equipment to make the IDs that the Arizona Motor Vehicle Division is using. So you have to, in order to protect yourself, the gold standard is, one, is you have a picture of the person, you have a video of the person coming in, you have them presenting an ID card, and then you have either the scanner take a video, a picture of the card, so you have that record, and now you match the person with them presenting it, or you have a overhead video that you have a camera pointing down, and you have every ID card you put on there, you make a record of that, so that way you put those two together. You have to put them together. If you don't, then you know, you're subject to having some problems later on with that. The one thing I would say too is that with this obviously intoxicated, there's two situations for over-service. The one that's in for statutory liability is a higher standard than the one there's another section, 4-244 14, which kind of talks about over-service, but it also includes serving someone who's disorderly or obviously intoxicated. So that's a kind of a lower standard. So you actually probably could be written a ticket for 14, but not for not be subject to a violation, which would be for the obviously intoxicated. The liquor department's going to charge you with 4-210 9 and paragraph 9 and 10, which is failure to protect. So those are the kind of the So you have the civil, you have the administrative against your license, criminal against people, and they can, the local law enforcement, sometimes they write tickets to the manager or owner, but there's some case law in Arizona that talks about that if depending on what the violation is, that they really can't write a ticket to the manager. If what he did wasn't directly responsible for the violation, they'd have to name the entity, and that opens up more doors because it's harder for prosecutors. And I will say this, generally speaking, the city prosecutors and the justice court prosecutors, they really don't know Title IV very well, to be honest with you. They don't get that many. They may see a lot of underage tickets, but when it comes to these other statutes, and there's only in Arizona, there's maybe 4 to 6 attorneys that have a concentration in doing Title IV liquor law work. And the reason why that's the case is because Title IV is written in one of the most confusing, long-winded, self-contradicting set of statutes. I had a councilman who was Linda Ronstadt's nephew in a case down in Tucson, and I asked him if he understood Title IV, and he goes, nobody understands that. It's like it was written by the mafia, and maybe parts were. I don't know. I haven't been around long enough. But in any event, so one of the things that I wanted to kind of get to is we're going to go to recommendations to actions. So let's take a look at it. I mean, first, one thing I think that's important to understand is, this is a really bad car accident or a motorcycle accident, and there's serious injuries. And there is, part of these cases are emotionally distressful. And it could be that, a young person died, or God forbid, children in the car. And so you have to understand that there's just part of human nature. There's going to be a desire for people that are involved with any way associated with this, and even if they may or may not have been, we're going to be over and comes from the scene and punishing the people that are associated with this. And do not underestimate an officer that has, just got out of the hospital and is coming to to your business to do interviews or to talk with you, and they may very well be very motivated. I've had a number of cases where it seems like some of the information that they gather seems really biased. Like one thing is somebody was just in a crazy car wreck, driving the wrong way, and he's on a gurney, and the police officer said, and as he was being loaded in the ambulance, he kept saying, "Why did they serve me so much? Why did they force me?" And you're kind of like, I don't know, if I had 2 broken ribs and a broken leg and a concussion, would I really be blaming the bar about but anyway, the most important thing is I think I'm going backwards.
Other way.
All right. So the first thing is if these things are they're you're going to be shocked when these things happen, and I want you to kind of have sort of an understanding of what are the things you should do first. The first is you may end up having Channel 3 and a news reporter at the front of your business. You're going in to open up for the day, and all of a sudden Channel 3's out there, and you get some may say ambushed. So the first thing is until you know the facts, don't make any statement. Just say, hey, we're in the process of reviewing the information. Obviously, we certainly comply with all laws, but I have no comment at this time. Generally speaking, even after we've thought, you know, I've gone through this process, I don't know how many times with clients, we're thinking about, well, should we make it, it's our reputation, and, and at the end of almost all those discussions, it's almost 100%, we make a decision to not make no comment. Because the bad news is going to be out there. They're going to tag your place with the accident. And the other thing is that provision in the insurance policy, you don't take any steps, don't make any statements. It's always going to be safer to not say anything than to try to guess it. Well, we always do a good job in here, those kind of things. They don't really seem to help much, and by the time you end up doing that, when it was done, it came out, it did seem to help much, and why take any risk at all? So
you're one news story away from them forgetting anyway, so better to wait till the next news story comes out and gets their attention.
All right, so then the next most important thing is preserving evidence. So we talked about the camera situation. The one thing I will say this is just the opposite of preserving. There has been some people in the past that they actually knew that there was bad stuff on their camera, and lo and behold, all of a sudden there's a day 8 hours missing on their video. There tends to be the judges will. It seems to me, in my opinion, they go out of their way to make sure that you feel the wrath of God for having that information missing. And there is actual cases out there where somebody, tried to be cute, and, made up stories, and it just, I would, as bad as it may be, it's not going to help by having, you destroying evidence. The other thing is now, considering video, there's no actual requirement that you maintain videos, but there is a question of, once it is a video, you have that record. Is it a record? We've never had any cases on that. Obviously, you have to preserve the video. There's no doubt about that. But you're also going to have to keep, as part of your requirements under Title IV for sure, you're going to have to keep the receipts, you have to have an employee log that's going to show, it's going to get your employee's name, birth date, phone number, address,
position.
Yeah, and that's the first thing that the liquor department in the investigation is going to look for. And so you have to have those things. If you don't, that's a violation too. And just, in case you didn't already know this, the liquor industry is probably the second most heavily regulated industry in the state of Arizona. Maybe just second to maybe banking or something else. Just about, you look at Title IV, is there anything they didn't regulate in the liquor industry? So, but anyway, so you still have those, Craig's going to get in those inspections and what you need so that you're in compliance with that. There is now, the other question I have is, okay, because the timing on these cases are, you might have the administrative sanction against your license, maybe that will be in 3 months to a year. If you go to Office of Administrative Hearing, that's probably going to be about a year or two. The civil case, by the time that goes to trial, that may be 2-3 years. And so the question comes up is, do you have, you had an incident happen at your establishment. Do you have your employees that were involved in any way, shape, or form do an incident? So, what do you think the answer is on that? Let me tell you a poll. I'll just do a poll. I've never done a poll before. Who thinks you should have absolutely all the time, 100% have your employees do an incident report?
Do what?
Incident report. They write down what happened. They give you, hey, this is what happened, and they give it to you. They don't give it to us. All right. And so everybody else is, maybe they don't know. Okay. So here's the thing. First of all, what I would do is I would contact an attorney and ask them. Now, there's 2 reasons for doing that. One is hopefully they know, kind of like, hey, yeah, you should, because the case is going to go on for forever, and people's memories today on what happened today or yesterday are gonna be 1,000 times better. And it's all those small details that can make a huge difference in the case. And there is nothing better than for me as an attorney to ask a witness, hey, this happened 2 years ago. How do you remember everything? Oh, well, I wrote it down. Well, when did you do that? Well, the day after it happened, I fill out this incident report, and it refreshes their recollection. It also reminds them of what happened, right? So that could be really important. The problem is that incident reports is, are they discoverable by the other side? Because you want to get a good, honest impression of what's happening, so that if you ask your attorney, hey, should we have these, and he says yes, then that's the instruction of counsel. And then it's not bulletproof, but then there's the probability of the attorney going, hey, we want all your incident reports. Well, they were at the direction of our counsel, and that's attorney work product. And that gives you, it's not bulletproof, but it's a lot better, and there's a fight over it, and I'm gonna say we probably would win on it. The other thing, of course, is you should be really honest with your attorney right up front. First of all your communications are protected under the attorney-client privilege. Even if you haven't retained that attorney yet, he still has to maintain the confidentiality of that relationship, and you hold that privilege. It's not the attorney, you do. And now you can waive that by telling somebody what your attorney told you, but if you don't waive it, it's about as strong a rule out there that protects that relationship. And the reason for that is so that the attorney can get you to tell them all the good and the bad, and then they can have a real true assessment and advise you properly on the case. Because I can't tell you the worst thing for me is, I get involved, I go, oh, we got a great case, and then all of a sudden, there's this fact comes up, and well, hey, you didn't tell me that this blah, blah, blah. And they're like, oh, well, I didn't want it. Well, now that completely changes, what other witnesses I may call, or, whether or not we should resolve the case before going to trial. It really impacts, and it can be, for me, it's like having a rug pulled out from underneath me. And not only that, but I'm telling the liquor department and other people, hey, we did everything right, blah, blah, blah. Now all of a sudden, we have this glaring problem, and then now we've lost credibility, and then it just makes things worse, all right? And, that's why we have that rule, so we should use it. So, all right, let's just say that you had a wrong way driver incident, and these things can come down on you really hard, fast. I actually had a client that the guy left the establishment, I think like 11:45, drove the wrong way, they got pulled over, and there was an accident, there were some minor injuries, but the liquor department got notified by DPS, and the liquor department had an investigator out at that bar that night, or that morning, after midnight. So they're closing up, and they get, that's the worst thing you could hear if you're closing up at night, right? An authoritative knock on the door, which is Craig is famous for those things. And
I would wait for the back door to open. There's no reason to knock when somebody's going to come out.
Well, again, shock and awe.
A better way of doing it is just hit the pepper spray in the AC system, and then everything. I'm not saying that's done anymore, but that used to be done.
So anyway, and what'll happen is you have a manager and maybe a couple people are working there, and they have, they're tired. You remember, this guy, maybe they do, maybe they don't, and then they'll try to get some interviews in. So the one thing that and this is kind of this is where these cases sometimes really get decided is on the collection of these interviews and stuff. And we've, in Arizona, I guess maybe I was more trusting of the system and the police officers, 25 years ago than I am now. I like to believe that they're honest and they really, they're not going to write down bad things, or there's, leave things out that are pertinent, which is fraud by omission, essentially. But, we've had, within the last 4 years, we had the director, the deputy director, and a liquor agent all having to have to resign. One's on the Brady list, which means that, he lied under oath. There was, I read the Internal Affairs Investigative Report, 950 pages, and about 18 hours of video and recordings. And there were police reports that were getting written up pretty objectively by agents, getting sent into the liquor department, reviewed, and then scrubbed of facts or things that would make it harder for the case to settle at the liquor department. So after you kind of seen that, then you're kind of, and then there's just human nature. Liquor agents coming out, talking to your employees, it's busy, it's loud, it's hard to hear. They maybe interview 8 people, they got to you're taking notes on all this stuff, they're not recording it. And what are they looking for? They're looking for, what constitutes a violation. So a lot of that other, stuff that they hear that are good points for you and your case and your defense later on, maybe aren't getting written down. And then there's just human, there's mistakes and errors and, everything else. So what's the safest thing? The safest thing is to, first, when interacting with anyone in law enforcement, there is, as upset as you may be about it, you have to be professional, polite, respectful. And there are some attorneys, there's definitely some attorneys who are assholes, but there's also some law enforcement people who, they didn't take that job because they're people friendly. They want to push your buttons, and they want to put in their report, was uncooperative, got belligerent when I asked for this, they threw their employee log on the bar at me, and those things end up costing you because it could be local law enforcement that does that, but the liquor department sees this, okay, we know how to deal with these people. And that fine or sanction or, treating you, now you got fallen, well, they're anti-law enforcement or whatever. So you end up having that's completely shooting yourself in the foot on. Be professional, be polite, be respectful. Trust me, as much as you may not want to at the time, you will always be thankful that you work. But the question then comes up is, what if there's a serious accident, you're facing potential tons of exposure, civilly, criminally, and again against your liquor license. In those circumstances, the preferred approach is to say, look, and they want to interview your employees or you, say, look, hey, I'm dying to talk to you. I'd love to, but I attended this seminar at Fraser's Tavern, and there was this attorney, Pete Schelstraete, who told me that they should definitely have an attorney present, or I should talk to one before I agree to any interviews. And so, really, I want to answer your questions. I'd love to answer them. But Pete Schelstraete, just throw me out. So I'll accept that. All right? And you use me as an excuse, and that way, you don't look like the bad guy, and I look like the bad guy. Which is, I'm an attorney, so how much lower can I get? And that's probably the most important. Now, the downside of that is, but here's the good part of this is, one is you'll have some time to kind of find out what's going on and interview your own employees. Go, hey, did you serve Joe tonight? Or you find out kind of get a bit. But you can then contact an attorney. You don't have to. You throw me under the bus and then contact Andrea or hire them. Or you can talk to your attorney and say, hey, here's, because the downside is the cost of the attorney, right? Now maybe the insurance carrier will pick up the tab on that. That's kind of probably not, I guess. If I had, probably 1/3 out of the times that, I talked to the insurance carrier and they actually cover my expense, or it's covered through the other attorney. But the upside is now you've got a little more breathing room. You do a little more fact checking, find out what's the violations that we're looking at. Because what's the first thing that when you get pulled over for speeding by a law enforcement officer, they come to you and go, hey, you know how fast you're going? Well, you know, most people say no. You know, well, later on in court, if you contest that ticket, they're going to say, you know, no, I was definitely going speed limit. Well, how come when the cop pulled you over, he asked you how fast you didn't know? You know, now you do know. You know, there's credibility. The police know where they're going. They've been down this road, hopefully more times than you have, and so respect that. And the good news is you can call an attorney, ask about it, and they'll go, hey, listen, you know, this is how much I charge, and then you could say no, but you know, then you call the investigator back and say, hey, listen, we'll just have a manager present. Hopefully, it's always good to have someone else present there, because that way they hear the whole thing. Because some stuff gets taken out of context, and I can give you 1,000 examples out of a week, and I don't want to take up too much more time. And the other thing that the most important thing, one is have an insurance policy cover you. You'll be really thankful at that moment about that. But the other thing is you'll be really thankful if you did preventative things. One is have all your employees take talk for basic training, always. And the other thing is to kind of remind them on a regular basis and keep a record of it. You know, hey, like everybody's counting their tips at the end of the night or whatever. Just have a quick meeting. Hey, we're going to go over, what are the types of ID that are available, or how much can you serve to any one person at one time, which nobody gets the answer to that correctly. And then and then keep a record of it, so later on, if you do get pulled, hey, look, we've got everybody at top for training. We told them do not serve anyone obviously intoxicated. We told that to them. And here's the bonus on that: is that if that's true, and if you have an employee that had Title IV training and disobeyed your direct orders to sell to someone, then the department has to take, even if there's a violation, the department has to take that into account as mitigating circumstances to reduce the fine. It's in statutes, it's 4-210, paragraph G. So you get a bonus by doing that. At the same time, by taking all those steps, hopefully you don't have them. And the other thing is when those employees are being interviewed, if you have an attorney there, they're going, hey, did you have talk with have you where you told, and so you're able to get your kind of side of the story. All right.
You can buy your kids books and you can send them to school, but you can't make them learn. And this gives you that credit for buying your kids books and sending them to school.
So what do I want to know? How do you pass a liquor inspection?
Well, that's what we're going to go into.
Oh, wow. What great timing.
And real quick, before Craig jumps into it, nobody's immune to a claim. Like, I don't care if you're a pizza restaurant, a nightclub, a pool hall, whatever you are, you're not like, one of the worst claims I've ever experienced is 2 GCU students, I believe they were sisters, that got killed by a wrong way driver that left mellow mushroom. So it comes down to training and it's wild.
I was speaking at a conference one time with a bunch of folks in the insurance industry, and I made the comment, I said, everybody in the insurance industry is a bunch of a-holes. And then afterward, this guy grabbed me to the side and chewed me out, and he says, hey, listen, I don't appreciate that. He goes, I'm an a-hole, but I don't appreciate you putting me in that same category as insurance guys. So, I want to cover a couple of things.
You're not going to tell your attorney, Joe.
No, I can't tell those. Some of the things we talked about, or I heard them talking about, when you're going to request public records, even though there's laws on it, the agencies play games. So it's not just asking for a report, because I've done that, and then you don't get notes, photos, anything. You have to be specific. I want copies of the report. In fact, I want each version of the report. You'll find it interesting when you request the different versions and you get the first version versus what the supervisors told them to make changes to, if you can get both those. Now, they're going to fight you to get those. But if you request to some of these police agencies that you want video of the incident because the cops were wearing that police cam, you're gonna get the video and they're gonna leave the audio out. So you have to be specific and ask for audio and video of each of these things. It's amazing the games that they're gonna play with you guys out there. So you need to ask for notes, photos, all versions, all copies of reports, all versions, all copies of photos. And a lot of time when we get the photos in, we can see when they date stamped or actually took the photos, which it doesn't actually match some of the information in the police report. One other thing.
One thing too on that is it's a serious violation for the state to not give you what you asked for. If they willfully do that, it's a class 4 felony. So I mean, it's pretty. The public records law is supposed to be. We're supposed to have transparent government, which is I think pretty important. And it's really hit. And the other part is the liquor department's going to say, hey, we have the police reports from Schelstraete. We're not going to share those with you right now. We're going to end up going to battle on this because if they have their public reports and they have them, they should have to produce them and not have me have to go separately to the city of Scottsdale or God forbid Glendale. You know, I had a case that took me a year and a half to get those police reports. We already had the trial. I was able to get the reports somewhere else, but the Glendale sent me a letter saying, hey, do you still need these? I'm like, so anyway, sorry.
No, that's 100% accurate. And before we go on, Pete mentioned ALBA, Arizona Licensed Beverage Association. It's not just the Honky Tonk Bar Association, but they lobby and represent bars and restaurants. Their president, Dave, was going to come here today and give you a little quick background on them, but one of the bars he has a little electrical problem, so he sent his vice president in to stand up and tell you a little bit about ALBA. If you're not a member, please consider, because they are doing an amazing job at lobbying and looking out for the interests of bars and restaurants, breweries, distilleries, and wineries.
Thanks. I'm Daryl. I own a bar called Jester's Billiards. I'm the vice president of ALBA. I've probably been that for 8 or 9 years. All we are is a group of business owners that have liquor licenses. And we got together because we got tired of the state screwing around with our liquor licenses and making laws that we had no say in. So now we have a lobbyist that tracks all that down. We pay $300 a year in dues, which is minimal considering what we get. We're represented at the state level all the time. If you have any more quick questions, I don't want to take up too much time. I brought a bunch of little flyers here that you can get. We'd love to have you as a member. Thanks.
We'll touch on a little thing. And please, I'm not saying anything bad about the department. The Department of Liquor, we get a new director every time we get a new governor. And when we got our new governor in, we got a new director. And since coming in, we've lost about 90% of the employees have been pushed out and brought in new people. So they did a complete and total brain drain there. So now you're going to be dealing with a lot of newer people and new concepts and different ideas on what works for enforcement strategies. So chances are those of you that have been in the industry a while, Daryl, been around since Moby Dick was a minnow, he's probably forgot more than what their new people are actually learning. So just understand you're dealing with some people who aren't going to be as knowledgeable as you, but they're wearing a badge, and that gives them the courage to think they are more knowledgeable than you guys are. I will tell you 100%, and Pete hit it on the head, kindness kills me. All right, when I wore the badge and would go into places, I liked people who were confrontational with me because I just enjoyed that a lot more. If they were kind, offered me water or a bite to eat, that kind of drove me crazy, and I just wanted to get the heck out of there. So kill them with kindness, but keep your mouth shut. Right? You have the rights to not say anything. Obviously, identify yourself if they want you to identify. Give them your personal information, how long you worked there, that you've been to training. But if they're asking specific questions about specific incidents, always have your employees fall back on, hey, it's our policy here. We don't speak about specific incidents unless our owner or attorney's present. And that will buy you a little bit of time to calm things down. Every year when we get to September, October, there's a large group of liquor professionals get together. It used to be called the Omnibus Bill Group, and I don't know, they renamed it or couldn't use that, but it's a group of industry professionals get together and we discuss any items that don't seem to be effective or working in Title IV and things that need changing. Arizona, we have like 23 different license types. Other states have 150. So it's probably time for us to look at creating some new license types while still protecting those tried and true licenses that are around. If there's anything very specific that you guys can think of that don't make any sense in current laws, it's groups like ALBA, Restaurant Association, the attorneys you see present, attend those meetings and work with them, point out the things that don't make any sense, and I agree there's a lot of it in Title IV, but this is our time of year to get in there and get motivated and make some changes. Every year we get together, every year we make changes, and if you send your employees to training every 3 years, you're gonna miss out on some of those changes. Because we do affect things like the types of IDs you can accept, the amount of alcohol you can serve on different issues. So it's good to stay up. Yes, those training certificates are good for 3 years, but if you're active and involved, I think it's better to have your employees attend training more than once every 3 years, because it's, you know, after 3 years they tend to forget a little bit. Pete touched on it, you know, not only at the end of the night when your people are sitting together counting tips, but I really see the importance of having quarterly meetings with all your employees, documenting which employees are there, and addressing those high liability issues. That we do not serve anyone showing obvious signs of intoxication. We do not serve anyone who's underage. We go down a list of those very important items, list the employees that are there that heard the discussion, list the subjects you talked about, and do this quarterly and keep those records. That comes out beneficial for you guys in the end. Make sure you do have your policies and procedures manuals in place. Make sure the employees have read them. I would have a signing sheet at the back of it where they sign that they read and understand your policies and procedures if you have them. And if you have policies and procedures in place, you need to enforce them and follow them yourself. I would really watch your online presence on what your employees are saying that's going on there, what your employees are doing. We will try to monitor some social media, and I've seen you know, bar owners where a guy may have passed out and they draw like a chalk line around his body and put an arrow down. You're just asking to have the Department of Liquor come for a visit, and it's kind of hard to defend against those items. Those same photos will pop out in the civil case when DELO's insurance companies are trying to defend you. So scrutinize what you guys are posting yourselves in social media. We used to have to, when I worked at the department, we'd have to go get the New Times to flip to the back to find the violations. Now it's easy, the guys just sit on their phone and watch. And one of the big ones, people are still advertising bottomless mimosas, which you can't have a set price, set period of time, unlimited number of drinks. The ones who post it correctly, it'll say only includes your first 3 mimosas, each additional one after that costs $0.25. Then it's not set price, set period of time, unlimited number of drinks. So watch your online presence. One thing that we're kicking off will be coming next week. We'll pick somebody in this room. DELO has interest with his insurance carriers. We have interest to make sure people are able to pass an inspection. So combined, we're going to be going out and inspecting the people who have insurance from DeLorenzo and the clients that we work with. We're going to show up and do an actual routine liquor inspection at your facilities, just like the department would, but we're going to get more in depth and have answers for your employees when they ask them. So we're going to come in, check things like your liquor license, your employee logs, all those things that the department of liquor is going to come out and check. So we're going to come there from the ALIC and DeLorenzo side of things. I looked at, and we talked about that mail-in consent that the department is offering. I have yet to see them be 50% since this new administration. It's no longer a 50% deal. They may knock a percentage off, but I haven't seen it be 50 in the last couple months for responding. One of the big things that I see coming up, and it was discussed last year, hardcore, and it's coming up right now, is how the THC hemp industry is affecting the alcohol sales in Arizona. And the industry got together and tried to make it. Are we dealing with THC products out there? Yes, and there's THC that's derivative of hemp, and it's Delta, whatever it is. Not necessarily falling under the medical THC business. It's came under the federal farm bill. So we had a lot of places selling the Delta 8 THC beverages. In fact, I've seen it at special events and venues, which basically got the blessing of the local sheriffs and a winky winky nod nod from the state at the time. And then after last year, they came out and said you can't have those beverages. There was a big push to let our Arizona breweries and wineries make those products, because they're going to be out there. We're dealing with them. They couldn't get it through the state last year. Let's hope they can find some way of getting it through. Is the hemp business or the hemp THC business hurting the liquor industry? Yeah, because when I was a kid, we'd grab a case of Budweiser and head out to the river. And now the kids are just going to the store grabbing THC gummies and sitting at their house playing on their damn cell phones. So I'm glad I grew up years ago and not currently. Talking about recording IDs, yeah, ultimately, if you have a camera that takes a physical photo of the ID and my face at the same time, it's the easiest way to get those together. But then you have, you know, 2 cameras, you have cloud storage systems, and it gets expensive, so I understand that's tough. One of the big trends is to go with scanners, the hand scanners. If you go with those, make sure you deal with a reputable company that understands they need to upgrade their technology. And I'll just use this as an example. We have the honor of working at the Waste Management Phoenix Open with the Thunderbirds and doing compliance out there. And the scanners that we used were able to catch like 150 fakes a day. Whereas some of the security companies had scanners that all they do is record information. It doesn't actually read and identify fakes. So they were able to swipe them and it just recorded and captured the information, but there are scanners you can get out there that boom, will send you an alert, hey, double check this, or hey, this is definitely a fake ID. So if you're gonna look into getting scanners, make sure you do your research and find a quality one that they can upgrade the information. Right now you can go to the internet sites and these kids are ordering fake IDs for about $100 and they get 2 for $100. And I would say a good 60% of the cops can't even tell they're fake. And I tell you this because when we catch them at events, we'll walk them over to the cops and say, hey, we got these fake IDs. And they're like, well, you're gonna have to tell us why it's fake. So just think about that. If you're using a scanner, make sure you get one that updates the information.
The other thing too is that make sure you find out how long that information is held. Because, and if there's a way to download that and then you store it so it doesn't disappear, because sometimes these violations end up kind of further down the road. And if you have a 1-year statute of limitations, I mean, some of these things, it's only like 3 months, it seems like, or there's some amount that it holds and then it starts, you know, like your video system starts overwriting itself. But if you find out what that is and make sure you're keeping the whole thing so you have a copy of that, because once that disappears.
Hey, you guys, when should somebody scan an ID?
I think you should scan an ID anytime the person looks young. That is 35 and under is kind of what the industry talks about. I say anybody who looks young. It can be deceiving depending on where you're out. If you're outside and the ladies are wearing those big bug eye glasses like this, and you can't tell if there's any crow's feet, I've had them take them off. And you're like, whoa, didn't need to see it anyway. But yeah, anybody who looks young, I recommend you put in there because you're protecting yourself against those kids using their older brother or sister's ID or having a fake ID. And you're no scanner's going to catch every one of them, but that's what you're protecting against. Kind of the standards 35 and under is what it is. Obviously, if I come out and order a beer, there's probably no real need to check my ID. But anybody who has that youthful appearance. To protect yourself.
And if you don't have a scanner yet, don't worry. I'm sure Toast is coming out with one and it's going to upgrade.
I think you'll probably see that as the state keeps losing more money or not having enough money to pay their bills, there are creative ways for them to go out and fund the state, and one of the ways is to send the Department of Liquor out. You know, I would feel comfortable saying that if we went to any place with a liquor license, I could probably find at least 3 violations anywhere that serves alcohol. That includes, your guys' businesses that are here. Which brings us to, the training, because the law says employees need to be knowledgeable in Title IV liquor laws. We'll have a slide on that in just a second. You can send them to go sit at the Arizona Law Library and read Title IV, but I don't recommend that because that's a headache of a mess. I think we purposely leave Title IV kind of vague because we're a state that depends on people visiting, commerce coming in from, you know, us being a tourism state. And if we have those solid black and white laws, we can't adjust for trends. So we need to be a little bit flexible so we can adjust for trends, so we can stay on you know, leading edge for commerce. And so I like to think we leave it up to the attorneys to kind of interpret as it goes. The Department of Liquor may disagree with me on that, but I think we purposely leave them kind of vague. So
Which is job security for attorneys, which is the most important.
And liquor liability, I'm hearing a lot of people are coming in, we're talking about liability insurance, so I hear someone saying, well, we're just gonna operate without liability insurance, and if we get sued, they can just have the damn place. I understand that theory because liquor liability insurance is getting more expensive, but I just, you know, like DeLo mentioned earlier, I was just in Globe for a week, hanging out, swimming. And only 3 people up there actually have flood insurance. Actually, only 2 in Globe and 1 in the town of Pima. I talked to the guy who flew out. So, and the key reason was because of how expensive it was. So, liquor liability is 100% necessary. Although floods don't happen often, they do occasionally. Liquor liability, it's not a matter of if, it's probably a matter of when. Are you gonna need it? I don't like to sit down, so I'm gonna bounce around. Available resources out there for you guys and your employees. Obviously Title IV, you know, the booklet, the statutes, the Secretary of State's website. Previously, the Department of Liquor used to have a nice booklet that you could look at online and be able to, you know, read the liquor laws, but they don't feel that's their responsibility anymore, so you got to go to Secretary of State now and see it. You can go to azliquor.gov. They just redid their website, and maybe one of you can give me a lesson on how it's supposed to work, because I can't figure it out. You can always call the Department of Liquor. Fortunately, I'll tell you, some of the cities have amazing liquor squads, like Scottsdale has a designated liquor squad in Tempe. You can always call those guys on those liquor squads. They're amazing guys to work with. They'll actually answer questions and try to assist you in getting your licenses approved. And they also run, you know, different security and training courses, which if you live in Tempe or you live in or business in Scottsdale, make sure you take advantage of those. If you have businesses in other cities, if you call Steve McDonald, just ask him. You can say that your employees work for him, and then he can go to that Scottsdale training. And especially if you're in the Phoenix area, get that done. So, Title IV says any place with a liquor license is subject to inspection anytime the business is occupied. That doesn't mean the flashing sign on the door that says open, it's occupied. So if you got Craig in there and I'm mopping your floors for the day and I'm the only one there, and they knock on the door and they announce they want to do an inspection, they get to come in and do an inspection. Now obviously if I'm the janitor, I probably don't have keys to the office, so they're going to be limited on what they're going to see. But they have to let them in. Those late nights, 2, 3 o'clock in the morning, if I was inside cleaning and someone's banging on the door, I'm probably not going up to the front door, to be honest with you. Let the cops knock all night long. Because I don't know if it's the cops out there or it's a robber. So I'll let them beat their knuckles dry. They can come in tomorrow when they know for sure somebody's inside. All I used to do, instead of knocking on the door, somebody's going to leave and take the trash out. So I would just stand by the door and wait for the guy to open the door to take the trash out, and then I gained access. Yeah, the pepper spray did work, but also we'd go around and kick people's tires till their alarms would go off, and then people ran out to see why their alarm was going off.
Oh, man.
I'm not saying they still deploy those tricks, but that is possible. So when they come in to do your inspection, the first thing they're going to do is look for a copy of your liquor license. You need to have a current copy of your liquor license posted where the customers can see it. We wouldn't keep it in the back kitchen area. It needs to be out where if the inspectors or any of your customers, they can walk around and see it hanging on the wall. So number one, they're going to make sure your license is posted. On it, they're going to make sure the name on the license, the business name, matches the name on the business. So we can't come here to Fraser's Tavern and it says that name on the license, on outside it says Craig Stinky Hooch, you know, that would be an issue. They can do a name change, but it's gotta be on there. Agent manager on the license is current and valid. Here's the big thing. Every business has to have a manager. It can be the owner, but it doesn't have to be the owner, it can be a manager. Now, if you get rid of that manager, we only have 30 days, or you only have 30 days to get the new manager fingerprinted, fill out the questionnaire, and get it filed with the Department of Liquor. 30 days is not a long time, but it's really important that if you have a manager leave, you get your next manager on file within 30 days. Now, the nice thing about your managers, they're gonna not only be required to take the 3-hour basic Title IV class, they're also required to take the 2-hour management class, just like the owners are required to take. It was designed to take the basic first and then the management, and it kind of should wrap all the information and their responsibilities together once they've taken the 2 courses. But it also requires you to submit a fingerprint for your managers. I recommend you sit down and talk to your managers a little bit about their requirements. Many times we've had them come in and we'll ask them the same questions that are on there. Have you been cited, detained, arrested in the last 5 years? We talk to them about it. Nope, they haven't been arrested in over 20 years. Okay, they mark no. And then next thing you know, we submit their fingerprint card and the Department of Liquor is calling to get a hold of them because they forgot 4 years ago they beat their spouse and went to jail, or they got in trouble for urinating in public when partying in Vegas, and some of them just flat out. We had one the other day who said she'd never been cited, detained, or arrested. She had got a DUI 2 years ago, and a DUI a year ago, and then a DUI 2 weeks before we filed the damn stuff. Like, yeah, she's not going to be on our liquor license. But you need to ask them the questions. We will ask them the questions again, and then they're going to fill out their sheet. I know it's crazy. We have to submit fingerprints in this day and age. All they have to do is enter your name and date of birth. They can get the same record, but they can't charge you to enter your name and date of birth. The only way the Department of Liquor can charge you is when we submit a fingerprint card. So we have to submit a fingerprint card on all of them, and it will find out the details about any of your employees that have been cited, detained, arrested, all those things. So,
Is that valid for?
pardon me?
How long is that valid for?
The fingerprints?
Yes, sir.
2 years. Now, you don't have to, as an owner, go in every year and turn in new fingerprint cards, although I think this current administration would like that. But if you're going to apply for a new business, or if you're going to try to help out at a special event, or if you're going to host a special event at your location, then they're going to require the management to have new and current training in. But historically, if I had opened a bar in 1970 and I took training in 1970, and I was never going to open another place again, I didn't have to repeat training, unless I was going to open another location. But today, it's getting a little more strict, which 100% I do believe you should send your managers, the people who are controlling the day-to-day activity, at least to school every other year, just to keep up with the changes that are taking place out in the industry. Next thing they're going to look for is the ownership. I had a friend who used to tell all of his buddies, yeah, you can tell everybody you own this place or that you're one of the owners. And it was cool because then they ended up getting more dates out of there because people thought, you know, they were one of the owners of a bar or nightclub. But when the police come in and, hey, who owns this place? And you got 5 guys drinking in the bar saying, we all do, it causes a little concern. Because anybody with 10% ownership or more of a liquor's license or control of a license has to be disclosed to the Department of Liquor. So if you bring on a partner or an investor and they're now controlling 10% or more, we've got work we've got to do in filing and acquisition control and put those new owners on there. And then the other area I see where they catch a lot of people is if it says I own 100% of ABC LLC that owns the business, and then they look at your K2s and you've got a couple of investors, none of them up to 10%, so you didn't have them on the license, but it's not accurate if I say I own 100%, but yet I have 2 investors, even if they're 1.5% each. Then I need to adjust my ownership to only being 97%, So I have that extra 3%. My math's good today.
Yeah.
Yeah. Employee records are available, and we'll have an example of the state one. You can have that information in the computer. It's not the resume they filled out. It's not the application they filled out. It's a specific form that has the name, the date of birth, address, and position of all your employees. That's all. Now, whether they're chefs, front of the house, waiters, waitresses, bathroom attendant, if they're working for you, need to be on that list. And why does the department like to have that list? So then if there's any incidents and those people aren't there, they're gonna call them at home. Hell, when the Department of Liquor was investing me one time, they were pulling over the employees to interview them about me. Crazy. So just keep your employee records available and up to date. It's an administrative violation if you don't have it. Employees are familiar with liquor laws. It's the owner's responsibility to ensure that all of your employees are knowledgeable and Title IV. There's, the basic information, the maximum amount of alcohol you can serve to one person at one time. It's 50 ounces of beer, 1 liter of wine, or 4 ounces of distilled spirits. Anybody have questions or want to know how we went from 32, or how we went way back when we could serve 2 drinks to people? We had a location in Tempe that would fill mop buckets with beer. So that was like, we got to figure something out. So they started looking at what's the maximum amount of beer we should serve to somebody, and the tall pitcher was 64 ounces, the half pitcher was 32 ounces. So 32 ounces seemed like the right amount, so people could get pitchers. 32 ounces of beer is not that much, especially some of the lighter beers. And then you had a lawmaker go to a ball game, wanted to get he and his wife a beer, and they were selling 20-ounce beers, and so that was over the 32 ounces. So they had to change the law, make it 40. And then that same lawmaker went again, and damn it, if Hensley didn't come out with 22-ounce bombers, and so we had to change it to 50 ounces so he could get he and his wife a beer. It's always been 2 ounces of spirits, so they didn't interfere with happy hour where they have the 2-for-1s. That way they didn't interfere with happy hour. Isn't it stupid? You can't say buy one, get one free, but you can say 2 for 1. Because if you say buy one, get one free, they consider that an inducement to purchase alcohol, even though at the end of the day it's the same damn advertisement. And 1 bottle of wine, because a lot of fine dining restaurants, i.e. you can see in the back, this is how you'd order your wine, is by the bottle. I mean, if you're ordering it by the glass, you're just going to wear out your waitress, so buy a bottle. Floor plan has to be approved and authorized by the Department of Liquor. They want to know the square footage, entrances and exits, if there's a patio that's approved, the areas where you're going to be storing your alcohol, and I'll show you a map that kind of shows what they're looking for. Diagram's very important, and you need to make sure you keep a copy of it, because I've seen people add on or build. We've been looking at some of the golf courses lately where people want to do a special event out on the golf course, and so when we request a copy of what they have on file with the Department of Liquor, the only thing on file is their clubhouse. They forgot to add any of the course in when they actually applied. So now, to do a special event out there for them to serve, we have to apply to do an extension of premises from just their clubhouse to now cover the course. And wouldn't you know it, City of Phoenix now says, well, even though you've been serving alcohol on the golf course for 20 years, and we know that's been going, now you're going to need to get a new use permit to show that you can serve out there where you've been doing it for 20 years. So it's maybe worth it for some of you to, especially if you've been open for over 20 years, to request from the Department of Liquor and see what you actually have on file as your diagram, because I'm pretty shocked at the number of places that their diagrams are messed up. And why give them an easy ticket to write? Or have them show up and say, hey George, you didn't add this half the restaurant, so you can only serve people in the bar. And that can really damage some of your business. Make sure your patio is authorized. Again, City of Phoenix, you can build a building, add a patio to it, but you can't use it until you get permission from them, which they call a use permit. And it's the craziest thing with Phoenix. We had a place on an outdoor patio. You have to describe what kind of lighting you're going to use, every business around. You have to notify everybody a mile and a half. We even described the exact speakers we were using. We described the brand, the output of them. They approved everything, and they said you can have the use permit, but you can't turn on the speakers because you didn't say you were going to power them. What the hell do you think we were going to do with the speakers on the patio? So there again, it's those games they play. Hey, can I get a copy of the video? You get the video, no audio. You got to ask for both. If you're going to tell them you're going to have speakers, you got to let them know you're going to run power to the speakers to make them work. Only IDs are accepted, and we've got the. And I do recommend everybody reach out to Alba. They do have a poster which has an example of all the IDs that are acceptable. Go ahead and spend your couple dollars, buy that poster from Alba, stick it in your employee room so they have it to look at, to remind them of what types of IDs. If you're not going to use a scanner, I do recommend you get an ID log. That's where you write down today's date. His guy's name's Craig Miller, license number boy 127554. That is it, by the way. You want them to sign it and then put the initials of who's checking their ID. Why do you want them to sign it? Many times if they're using their older brother or sister's ID to get in and drink, especially if they had a couple cocktails, they're going to go sign their real name first. You signed Craig, but the ID says you're Jim. You know, those kinds of things you'll be able to pick up on real quick. Written log is good. It helps to protect so you can show that you checked the ID. But I'm telling you, I've been into hundreds of bars doing ID checks, and as soon as the first flashlight turns on and I step up to somebody saying, hey, I need to check your ID, there'll be a mad dash of young kids running to the bathroom or running toward the exits. The ones who run to the bathroom ditch their IDs either in the toilet or in the garbage cans. And now when they come out, the cops grab them. They've got 17, 18-year-old kids with no fake IDs in their pockets, and they're going to claim they didn't show an ID to get in, and that's where either the video or the written log comes in to help protect you guys. And spirituous liquor is only supposed to be stored in authorized areas. There are times that, you know, there's a great deal from Jason at Breakthrough Beverage, and so you want to take advantage of the bulk deal, and you don't necessarily have room in the bar or your storage area to keep it. So I have seen people build a tough shed out behind, and then they keep product stored out there. Totally legal as long as you get permission from the Department of Liquor ahead of time to have off-site storage. Don't store it out there and then wait for the department to catch you. Just request off-site storage ahead of time, and you shouldn't have an issue. I can tell you they dislike off-site storage being at a private residence. I offered all of our clients that I would store their alcohol at my house for them if they wanted me to. The department said no. Unauthorized alcoholic beverages on premises. Basically anything you buy from anybody other than a wholesaler or a licensed farm winery, craft distillery, or a microbrewery in Arizona. That you can't go and buy retail alcohol. And you know, I've seen bar owners, you know, they're working at the bar, and I travel to Europe or whatever, and I bring them back a bottle of Pimm's, and I bring it to give them, hey, here's a bottle of Pimm's straight from Europe. Just the fact you brought it in and gave it to them technically is a violation because they can't allow unauthorized. If it didn't come from a Arizona wholesaler or one of our craft distillers, you shouldn't have the product inside. I see it occasionally because you got the home distillers and the home brewers, and they want to bring their product in. Hey, you should try this. Let your customers, you know, see what they think of this. It just can't happen. If you run low on Jack Daniels, you can't run to Safeway, get a bottle of Jack Daniels to serve for the rest of the night. You got to wait till Breakthroughs will call opens or have them deliver it. I don't understand the theory behind that, because why not let them collect tax twice, right? If you run out of Jack Daniels, you know, why not let them run to Safeway, pay tax on it, bring it back, and then collect tax on it? But the state doesn't, just so they can ensure consistency and quality in the products you serve. There have been other countries where there's a big gray market alcohol, and people are going blind or deaf or dying from drinking bathtub hooch. We haven't had those issues in Arizona because of the fact that they require it to come from the 3-tiered system. I'm going too long?
It is almost 1 o'clock though, just so you know.
So you guys took up all the time and then
And then you,
Is everybody okay for Craig to go a little bit longer?
how about I just finished it down here? We're about right here. Liquor bottles cannot be refilled. Okay, so if you got 2 half bottles of Crown, we can't mix them together and have one. I see it done at a lot of the big venues. You just got to operate with half-filled bottles. No marrying your bottles. Although we do it at some events, I get it, but that's just to get things done and get the product out. So no marrying bottles. If you're a convenience store or grocery store, you shouldn't have any open containers on the premises unless you have your permanent sampling privilege. And if you do that, you need to keep your stuff locked up in between your samplings. Make sure your draft spigots are labeled. It doesn't have to be like the old days where it's actually on the bottle itself. It could be a menu. And I really like the way it's those black handles. And there's a chalkboard telling you what's coming out of each handle. Just make sure it is accurate. There was a day, a location not too far from here, where they had a game, a drinking game, where they would fill mugs of beer and then you chug them against each other, and whoever won got a prize. And so we're writing them up for drinking games, and then the guy comes on and goes, "Is it really a drinking game if we're serving non-alcoholic beer?" Well, technically no, but it is a violation because you're putting it out of a real beer tap, so you got to take it one way or another. Only authorized credit extended. We're a COD state. Before they leave, they pay their tab. I mean, that's just how it is. There's no Wembley's or whatever that guy named. I'll gladly pay you. Wimpy? Yeah, Tuesday for Budweiser today. Yeah, you just can't say those kinds of things. Make sure you, obviously, I've done it before. I had a few too many cocktails and forgot to pay my tab, but fortunately I left my credit card behind so they could bill me for it, or unfortunately. And then I got it back the next day. No inducements. Remember, we can't offer an inducement, so you can say 2 for 1s. Don't say buy one, get one free. Don't say buy a margarita, get 10% off premium appetizer. If you're requiring them to buy alcohol to get something of value, it's a violation. Fetal alcohol warning sign. You got to have that posted. That's that warning sign that says, "Warning, if you drink alcohol, you could get pregnant." They technically should be within 20 feet of your registers. For the most part, the department's always been comfortable as long as you have one inside. Have your liquor license posted, have your fetal alcohol sign posted. If you choose to be an establishment that doesn't want people carrying firearms inside the building, that sign actually needs to be next to your liquor license. Would make sense to be on the front door to warn people, but no, it's got to be inside next to your liquor license. So there is a possibility of somebody coming in carrying a concealed gun, just to look to make sure you meet the statutes and they see if that sign's there, and then they'll take their gun out and put it in their car. Craziness. Security, if you're using anybody in a security position, they have to have filled out and have notarized a security attestation. It's where they're swearing they haven't been arrested for beating their spouse or any other violations in the last 5 years. They sign it, have it notarized. You're required to have that for every security position. If you have security people that you are hiring and bringing in that work for you, you also have to file with the Arizona Department of Public Safety security form. Basically, you're telling them you have your own in-house security. You have to show them a copy of what uniform they're wearing. Not only reason they want to look at what you're having your security people wear is so they wouldn't be looking more like cops than just security. The standard black security t-shirt is what most people are using. Very important. I've seen that come up a couple of times when they hadn't filed with Department of Public Safety, and they are asking security now, and I have seen citations issued to bar owners who don't have those security attestations on hand. I'll tell you this about people you're looking at hiring for security. Do a little bit of a background check. If they show up in an affliction shirt, don't hire them. If they're super into cage fighting, you probably don't need that. Some of the best I've seen have been ladies that have been working the doors. They're just more attentive on catching the young people, and they do a real good job scrutinizing the IDs. I'm a huge fan of looking and hiring school teachers from the local area to work in those positions, because they know the age of the kids. Are really good at determining ages, and they'll know some of the kids trying to sneak inside. So if you can employ some of your teachers from the local schools, And the other things on here are I've got a whole bunch of slides. I'd love to sit and talk about more slides, but DELO will drown me. So thank you all for letting me talk for a few minutes.
Any questions? I'm sure there's a ton, right? Go ahead, Jess.
Has anybody done this or thought about doing this, suing a minor that came into your club and got cited for the fines that you got?
Yes, some people have thought about that and it's been discussed. No one's really gone forward with it. I think there has to be, if you're gonna do that, has to be some kind of notification up front, saying, hey, if you commit a crime or blah, blah, on premises, we'll see your ass off, or however you wanna say it. But I think you have to kind of put them on notice. That would be the three of them. But there has been some discussion from previous owners talking about that, but no one's done it.
Stopped pretty quick, they started having to pay.
Right? Go ahead.
Sorry, I don't know, are the police departments still doing stings with sending kids in
Yes.
to try?
Yes.
The cop
They
detail?
are?
Yeah, it's called the Covert Underage Buyer Program. It's typically the Department of Liquor, but there's some local police agencies are showing interest in doing it their own. Thank God Eddie Basha was involved years ago when they changed that, so they have to have an actual suspicion before they can come in. But how they gain suspicion is interesting, if they drove by and saw a kid walking out, well, now I suspect them of selling to kids, so they may come in. Here's what I'll tell you, in anywhere we work, in events and stuff, I tell people the first words out of your mouth when somebody's coming up to buy alcohol is, how old are you, if they look young.
And that's what I was wondering, that was what we did in Nebraska all the time. And if you lie, you can't lie, is what we were told,
Yeah.
and it gets thrown out immediately.
Yeah, they can't lie, but here's what I'll tell you, if you just count on, thinking that you're gonna ask these questions, the Department of Liquor doesn't do it all that often, nor the local, but there's 400,000 underage kids at ASU that will lie to you. So if you're just counting on the fact that, how old are you? You know what I mean? And that they're gonna be honest. Yeah, so the 1 out of 1,000 that the Department of Liquor sent in, but you're gonna miss the 4,000 that ASU sent in. ASU doesn't send them in, but it's their fraternity, sorry.
Thank you.
And the commissioner in Nebraska just got indicted.
I know.
He's kind of introduced with the strip club.
I did go out and teach in Nebraska a couple times. I didn't go out with him, by the way.
Field trip.
Yeah, he actually was pretty good to deal with.
He was actually a really cool
Well,
guy.
yeah.
Yeah.
Did you have a question? Oh, no, okay. Yeah.
What is the situation with liability with regard to single person accidents, like a motorcycle rider that gets in an accident on his ride home and no one else is injured, just him or them? Where would that sit with the liability issue?
Well, so in other words, he was the one that was actually the patron and
Yes.
gets in an accident. So, well, first of all, there's in Title IV, and this I don't think I've ever seen the liquor department write a violation out, but it's actually in 4-244. There's a paragraph that there's two paragraphs. One that says you can't serve someone who's can't overserve, basically, right? But there's another paragraph in there that says if you're obviously intoxicated, that you're not supposed to order or continue to drink yourself. And Arizona does impose upon the person that goes in, and actually, and I think this is the really who's the person that knows best how much they can hold their liquor and if they should drink anymore. And that's the person that your patron that comes into that person. And the actual amount allocation of damages in those circumstances, that person picks up a percentage of that. So there is going to be a reduction. They're going to be at fault for some of it, if not all of it.
So,
Yeah.
so family sues, so the motorcyclist gets killed or injured, and his wife or spouse sues the establishment for over-serving him. That could happen.
Yeah.
Oh, yeah.
It is that.
Yeah, it has. It has happened. Gary, any of those cases that you remember?
Yeah, I do them all the time.
Yeah.
The tricky part is that in the statute, it still says that they can't sue you for someone's self-intoxication. I don't know why the statute hasn't been amended because there's a case called Schwab versus Matley that says that provision is unconstitutional. For the reasons that Pete was talking about, and how it's a comparative fault issue, and so there's a case directly on point. There was also belief that Torres changed that. Torres did not change that. In fact, the Torres opinion specifically carves out Schwab and says no, it's still unconstitutional. So you can sue for your own self-prosecution injuries.
Yeah. So, yay, Arizona. Anything else? Awesome. I really appreciate y'all coming. I think we'll do something like this again, like maybe after the open, just to keep you guys, apprised of what's going on.